Welcome to the DWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the DWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 95 of the DWI Guy podcast. On today's episode, Marcus Hill is back. He is back with us again. He was on episode 94 last episode, so go and take a listen to that first if you've not heard that episode already. On today's episode, and also go back to episode 94 for a little bit of background about Marcus, who Marcus is, and why he's engaged in DWI defense. On today's episode, Marcus shares some of his practical tips for how to prepare a district court DWI case. Very helpful and practical advice. Think this is going to be something that changes the way that you practice. Hope you enjoy today's conversation.
In that regard, I think the other thing that I see a lot of folks not doing, I think is really important, is I prepare the client for court starting with the moment they walk in the door. So I tell them I'm not going to be there when they call the docket because I'm not there calling the docket. Some lawyers feel like that's really important. I'm not an early person and there's really nothing for me to do there. So as long as the client doesn't get uncomfortable that I'm not there, then there's no reason for me to be there then, and I can be doing other things while that's going on. But then the other thing I talk to clients about is how to behave in the courtroom. And something I think that a lot of lawyers miss is I am friendly with my clients. You see, the judges know me and like me. And if they think I like this person, then they just sort of default to liking that person, even though that's a defendant. But if you watch lawyers in courtrooms, most lawyers don't like their clients, and they make that really obvious.
That's
so
right.
They don't sit with them. They don't talk to them. They don't touch them. And I know in COVID, it's changed a little bit, but I still tell the clients that I'm going to come and sit next to them, and I'm going to sit closer than they like. And they need not to flinch away. They don't have to actually like me. They just have to pretend to like me. They have to sit next to me while I often lean over and pat them on the shoulder.
Oh yeah.
Just say, this is a great performance, isn't it? You know, I don't know. We don't really have anything important to talk about, but I want to make sure that the judge knows I like them and they like me. So oftentimes I go out and get them out. And then when they come out of the benches, I step behind them and pat them on the back. I know that seems like a little thing, but I think that makes a big difference in the way the judge perceives your client.
That's huge. And it's funny because there's been several guests on the podcast, Marcus, that have talked about this really more in the superior court jury setting, but not so much emphasis in district court. And it's actually great to hear that, you know, or to have reemphasized how important this is really at every hearing. That there's a local attorney in town here, James Mills, that for a continuance will do such a good job of when his client comes up, kind of giving the judge a little bit of background about who his client is and, you know, why we're continuing this case so that he can do X, Y, Z. And, you know, if he just said, you know, we're asking for a new court date, DA, no objection, it'd be continued, but he doesn't miss that opportunity to have that kind of human interaction with his client in the courtroom. And certainly on a day that you're going to go to trial, trying to kind of build that kind of psychological framework into place from before the case is even called is really important.
Right. And the judge is paying attention to what's going on in the courtroom. So if you don't prepare your client that that's going to happen, then you come sit next to them and you sit inside the friend zone. They're going to move away, and then that's going to blow the impression entirely. So you need to prepare them for that. I think one of the things that my partner tells me often is she says, you do this every day. So it's secondhand old hat to you, but for them, it's their very first time and they're terrified. And so you need to reassure them and tell them things that you think they should already know, but they may not. So in that vein, I have a process by which I prepare people for trials. I sit down with them and I try to do it less than a week before court, because I used to do it early in the process, which they liked, but then they forget
about it. Yeah.
And then it's hard for me to, I don't know. I don't like doing it twice, frankly, but I also,
that makes sense.
I want to do it so it'll still be fresh. And I have a page on my website that you've already noticed called the Witness preparation guidelines or witness guidelines. And I call it my witness prep page. And I wrote some stuff about how to testify. I stole some stuff from other people about testifying in various types of cases. And then I sit down with the client and talk to them about what I expect from them in testimony. And I explain the theories of Dr. Eckert. You probably know, but Dr. Eckert talked a lot about how to tell when people are lying. If you ever saw a TV show called Lie to Me, that was based on Dr. Eckert's theories. I think Dr. Eckert's theories have been conclusively debunked. And I don't think that's how you tell if people are lying. On the other hand, that's how almost everybody thinks you tell if people are lying. And so people believe it. It's the micro expressions and the look up and look down and all that body language stuff. There's a new book by Dr. Lenny called Duke, which is a great book and you should read. And it talks about how you tell if people are lying in a very rigorous scientific way. He measures these things and has found significant correlations with this seems like you're lying and you are in fact lying. So I think I tell the folks that they have to look me in the eye when they answer the question, for instance. And then I show them how to do that and how not to do that. Famously, I always ask them to ask me if I sleep around on my girlfriend. And then I show them how not to answer that question, which they see and don't believe. And then I show them how to answer the question, which they then believe. And then we practice a little bit with questions and answers. And you'll get some people that are really intuitively good about that. I'm a salesman. Salespeople know this, from the bottom of their soul. This is what we do. But a lot of people don't know it. And some people are very good at it. Other people are really crappy at it. But if you work at them, and then sometimes if I feel like they need remedial training, I license a mother, a girlfriend, a brother, a friend to practice with them on asking questions and answering. Because I think, you can get a lot better information from a witness that testifies if they know how to do it and they present themselves well. Additionally, it makes them feel like they're part of the case. And that's an important part of what a defendant's doing in the case is it's their case. So they need to feel like that they're involved in that. And even if I know I'm not going to call them, I'll still prepare them to testify. And then I ask them, do you want to testify? And tell them I think it's a bad idea, but your case, your choice. So I think that's another bit of preparation that you do. And I also tell them early in the process that we're not going to prepare for the case until just before the case is going to be heard, because that's when it's freshest. Sometimes they call me and want some reassurance and I can give them that, but I'd like to do that prep. And it takes me about 15, 30 minutes to do the prep. Sometimes you can do it in the courthouse. That's ideal for me because then it's very fresh and then they're good at it. But I like to do it about a week in advance. Once again, I think someone said the best improvisers are the really prepared folks.
That's right. No, that's totally true. I love all of those levels of preparation. I mean, it's just something as simple as explaining, why I might not get into the courtroom until mid-morning. I just think that is such a helpful thing for the person. If that's the expectation going into the courtroom, then, the calm, easy feeling. If you're not prepared for that, even if everything is going normal and your name's called at 9, it's like, they're calling you on the phone. Where the hell are you? Like, you're supposed to be here in the courtroom with me right now. I don't know what's going on. I don't know if I need to talk to the DA. So obviously such a simple step, but it is so easy to kind of get on this mind frame of, well, I walk in and out of the courtroom every day. I see people testify every day. To me, and this, I've never testified in court, but it just seems like that would be one of the most horrific experiences that a person could go through, depending on the circumstances. There's so much pressure, especially if people aren't used to talking in a public setting, having to put their hand on the Bible. And now you've got this person in a robe sitting next to you. You're staring out at a bunch of people in the gallery. There's 2 people with suits that are asking you questions through a microphone. I mean, just, if you're not used to that situation, it just seems like it would be terrifying. And so just whatever level of preparation that you can give. And obviously what you're doing with people is great in terms of kind of giving them that perception of, hey, here's what's going to go down. Here's what, what kind of questions.
Right. And you might also tell them about the tricks that the prosecutor might, how the prosecutor is going to ask you questions and why they may trick you. And I try to practice with those things because I know my prosecutors and I know my situations and I know my case, so I can sort of give them some idea. But really the short version of preparation is just tell the truth.
Right. That's
not tell the truth. You can't just tell the truth. You have to appear to be telling the truth. That's as important as telling the truth, is that you appear to be telling the truth. So, and if you teach them, and I think most people know this intuitively, but they probably have never thought about it in their conscious mind. And then they're in that pressure situation. They do a terrible job of it.
Yeah.
Awful sometimes. And I feel like if they do that, then that's my error because I didn't prepare them, in a way that might get them to the right state.
Well, it's kind of the same thing if you've got somebody that's stopped on the side of the road and the officer comes up to the vehicle and then, either tells them or says later to the court, they appeared nervous. Well, it's like, well, yeah, there's blue lights going on. There's an officer standing beside me. Same thing in the courtroom for that witness. If you appear to the judge or the jury to be nervous, maybe that's some sort of like a, subliminal indicator that this person isn't telling the truth, or maybe that person's just really nervous to be in the courtroom. So I think that is, again, it's not to say that you can make all those nerves go away, but one thing we'll do, especially on the jury cases that we have, but even in district court, is talk about the formal setting that this is in. The courtroom that's here in Asheville that they do most of the jury trials in is this massive courtroom, very ornate, high ceilings and all of the crown molding, and sound doesn't travel particularly well. It's just massive and it feels very intimidating. And it's just kind of like, I tell them, everybody that is in this room is nervous to some level, including myself. Like there's just nerves going through the courtroom. The people that are sitting in the jury listening to all this are nervous and they're not even having to talk. It's just that type of a courtroom. So just trying to minimize to some extent, the nerves that are flying through. And sometimes I'll just say, if you're feeling nervous, it's okay to talk about that. Nobody's going to hold that against you if that's the way that you're feeling about things. So
that's true. I tell them everybody's nervous.
Yeah.
and so don't be ashamed to say, I'm really scared.
Yeah.
This is not something I'm familiar with. So give me a second, or maybe I misspoke because this is terrifying. And that's all good. I think jurors understand that, because I think jurors can put themselves in that position and think how difficult it would be to get up there. And so I don't think you can prevent them from being nervous. I think you can make them understand what's about to happen. And that means they're not afraid or, insecure about what might happen. They're still going to be nervous.
Exactly. Yeah. Well, I guess in terms of that kind of next step of the kind of process on your end, once you've kind of written that closing argument, after the initial consultation or initial kind of look at the case, what's the next step in the process in terms of kind of preparing for district court?
Well, in district court, I do something that nearly nobody else does. And I've been preaching this at CLEs for years and nobody's taken me up on it. So
I think I know what you're about to say, but I could be wrong.
I file motions.
Okay.
And I file a Brady motion that's 20 some pages that has everything I've ever thought of in it. I file a motion I have motions, refusal, accident, blood test, breath test, and I file these very generic, every argument I can think of motion.
Yep.
And there's a couple of good things about that. First, the DAs no longer read them. So when I add something to it, they're like, oh, that wasn't in the one I read 10 years ago.
You emphasized this in a CLE several years back, and then we stole your motion to suppress off of your website, which has just so many great forms. But it is amazing because it's like this laundry list of different issues that you can bring out, and yeah, the DA doesn't even read them anymore. They just basically are like, oh, so what? They'll basically look at the motion and then they'll just ask me, so what are we arguing here? It's kind of just like I don't even want to spend that.
Right, but you can put in something unusual about it. So when they made us argue under Crawford that the breath test results shouldn't be admissible, and they send those forms out that says, "Are you agreeing that it'll be admissible without the breath test operator?" I don't sign those forms, but also they can notice you. So I just, in my Brady motion, it says I'm objecting. And so, at one point a prosecutor was introducing the breath test without having realized that. And I said, "I'm objecting." He said, "Well, it's too late to do that." I said, "No, I did that early in the case. Here, I'll show you." The breath test didn't come in. I mean, I think, sometimes there's that, but it's also true that you need to make a Brady motion because you may not get all the information. And I think when you put them on notice that you're going to be serious about that. And then when I begin a trial, I do two things. This isn't a direct answer to your question, but we're getting to that. When I begin a trial, I do two things. First, I ask the judge if I'll be allowed to record it. And I use a cell phone and a recorder app. And I always offer to send a copy to the DA if they request it, no problem. Some judges don't let me, and that's weird because there's, I think, ample reason that you should be able to record it, and there's lots of good case law, but some judges just say district court is an unrecorded court. I said, yeah, we're not paying a court reporter. It doesn't mean I can't record it. But anyway.
Well, this was another practice tip that I picked up from you early on in practice after one of the CLEs. You actually, I think, brought in at that time whatever device you were using. And I ordered it the next day and been using that one since. And it has done such an amazing job in terms of having officers feel more pressure. There's more pressure if they feel like they're being recorded. It locks them in from district court to superior. So, there's less of ability for them to think, well, it doesn't really matter what I said, 2 months ago. It's like, no, it was all recorded. I've used it in motions to preliminary indications, motions to suppress that were granted, and then basically kind of been able to get the DA to kind of agree, well, there's no new, I can't object to the findings of fact because they're laid out here basically in the recording that I'm attaching to the motion. So I think it's hugely helpful. If nothing else, even if you didn't push record on the recorder, but the officer thought they were being recorded, I think it would make a massive difference in the case.
I agree with that. And here's the story about that. I was in not one of my main counties, but I had my recorder, and it was big by design. I wanted the officer to notice it. And I make a big showing of noticing it because I want them to notice it. And then we broke for lunch in a DWI I was trying, and the bailiff almost always has to remind me to turn off the recorder and take it with me at lunch. And I went up and I had forgotten to turn it on. And I went, shit, I didn't turn it on. And he said, doesn't matter. They're all terrified of you because you record. You don't have to be recorded. You just have to pretend.
It's true. Recorded. Yeah.
They testify differently in your cases than in anybody else's.
Yeah, no, that's true.
Exactly what you're saying. I think that's really true. And that's why I asked to record it. And secondly, I make my Brady motion then. Now, I filed it in writing, and I've tried to get everything I can, but that very moment I say to the DA, I'm asking affirmatively at this point, which I think is the only point I can ask for Brady material in district court, for anything that might be helpful to me, either in trial or in sentencing. And I'm asking you, and I'm asking a police officer, and they always say, well, we've given him everything. There's nothing new. On many occasions, things have showed up that I wasn't provided. And even though I don't think you generally get a dismissal for that, you get a very favorable judge situation when they feel like the DA has tried to snake you by not giving you all the information you're due under Brady. And I think filing that motion and making the motion at the beginning of a trial cements that. And it also makes them a little afraid. And I know that the DAs often surveil their file in a way when it's my trial that they don't with other people, because they're afraid I'll find something that hasn't been discovered, and they want to make sure they've gotten everything out there, which I appreciate, allows me to prepare for the trial. But I think that in answer to your question, the first thing I do after I write my closing argument is I start preparing for what I will need. Do I need an expert witness? Do I need to go and do a video at the scene? And I often send the clients out to do videos of the scene, because I want them to be involved in their case. I think when they're involved in the case and they're participating and they feel like they're providing information, that makes them easier to deal with, and also makes them more part of your defense of their criminal offense. So that's all good.
I think that's very helpful. To just kind of go back real quick on the discovery piece, we different counties, do it differently in terms of what they will provide you, or if they're saying, we have an open file policy, we're going to give you the discovery on the first court date, we'll give you the paper discovery, but we don't have access to the video, whatever it might be. And in a couple of counties recently where they've kind of not been as forthcoming in terms of providing the video, I think Brady really allows you to say, well, if you're not going to provide the video in district court, I think you at least have to watch the video and verify that there's no exculpatory evidence. And no prosecutor in their right mind wants to spend any time on their own end trying to dig out exculpatory evidence. So it's just it's almost like a path of making it easier to just provide me the evidence. If you're going to do your due diligence as a DA and verify that there's no exculpatory evidence, you got to go sit down and watch this 2.5 hour body cam video that is mostly nothing, right? But it's on you to kind of go see if there's any statements that are getting made by the police officer at any point that could be helpful to my client. So I think you can really use that Brady motion to kind of give some credence to that.
I agree. And I had an interesting event where the prosecutor would not give me it's been many years ago, but wouldn't give me the police officer's report. And so if he calls the police officer at the early stages of the process refers to the report, and I object. And the judge says, "What's your objection?" I said, "Is he referring to his report? He needs to say he's refreshing his recollection." And then when it came my time to cross-examine him, I said, "Judge, can I see that report?" Of course, I can now since he's used it in his testimony. Yeah. Then I went back to my seat, and I put my feet up, and I just started reading. And 10 minutes later, the judge said, "Mr. Hill," I said, "Judge, I'm really sorry to waste your time and his time and everybody in the audience's time, but this prosecutor, he wouldn't give me the report in advance. Well, I've not seen this before. So it's going to be a few more minutes, Judge, before I'm ready." And I put my feet back up and began reading again. The judge, smoke was coming out of his ears on my case, in part because he was so angry at the prosecutor for making him sit there for 20 minutes while I read the report. Whenever it was my client, we talked about it, made a lot. I didn't need that much time to read the report. I just wanted to make a point. And the next time I had that police officer, he found me in the courtroom early in the process before the case was for trial and said, "Here, please take my report." I've made you.
That's awesome.
Because I don't want to go through that again.
Yeah, I think that there's not enough of those moments as a criminal defense bar where we're really kind of forcing these issues in creative ways like that, right? There's a number of different ways you could go about trying to get that report on the next case or on this case, but being creative in terms of where is the pressure point going to be on the state. Well, if the district court judge gets mad enough at the state about this issue, it'll probably get fixed. It'll probably go away. So I think that is such a great creative use of that situation.
But then the other thing I think, and this sort of, once again, I'm avoiding answering your question, but I'm answering it. I think you need to do your homework as a lawyer. And I think a lot of lawyers don't do their homework. And that frustrates me because I see them making arguments that they shouldn't be making or not making arguments they should be while I'm waiting for my cases to be heard.
Right.
And it frustrates me. It's a lot of extra work to do your homework, to read cases. Every week I get 2 or 3 emails with 10 or 12 cases or 15 or 20 cases in them that have to read. Mostly most of those cases don't apply to me. If it's about a murder case or a rape case, I'm not doing those cases. I don't have to read that. But you do need to keep up with your reading, and you need to have a good sort of reputation in the courthouse for knowing what the new cases say and for having seen the cases. I remember presenting a case to a judge that had just come down the day before, and he looked at it, and then he looked at me and said, "This isn't good for your case." I said, "I know that, Judge, but I feel like I'm required to present you with all the with all the law that there is, and this is new law that I know about, so I'm presenting it to you as I always will. And the good thing about that, it didn't do me a lot of good in that case, but it's going to benefit me over time, that the judges think I'm going to be straightforward and show them the bad law as well as the good, the bad cases as well as the good ones. And you can only do that if you do your homework. So
your website also has just such a great case list on it. It's something that really from the early days I have referenced regularly. I did a podcast a while back on some of the great North Carolina DWI resources, and your case list was one of those resources. I mean, it's just really well laid out in terms of subject matter. But again, like you just said, it has, cases that are favorable to the prosecution as well as cases that are favorable to the defense. And not only is it important because you have a duty to disclose those cases that are favorable to the prosecution, but if you haven't read the prosecution friendly cases, you don't know how to distinguish those. And there's so many times when a DA is looking at the yellow, notebook that they have from the prosecutor school that they went to, and it gives a summary of a case that, in all honesty, is probably not a very accurate summary. To say, accident is, accident plus PBT is enough for DWI or whatever specific case they're referencing. And it's like, well, if you read the case, that's not exactly what that's, there was other kind of extenuating circumstances that were going on. It wasn't really just that black and white. So, I think that sometimes just, not only knowing that so you could use it to present to the judge, but being able to distinguish those cases is really important as well.
It is. And the judge needs to know, I think, and one thing I saw in one of your other podcasts was that you need to be the guy that the judge turns to if he needs education. I often have judges and prosecutors and other lawyers calling me, and I try to always respond to those things and answer their questions, even though it interrupts my otherwise busy day and doesn't pay me money, because I want to be the guy that they call if they got a real question about a complex issue in a DWI case. I want to be the guy the judge says, let's call Marcus Hill and find out. And that you cement that reputation by saying, here's all the cases on this, judge, and I've got them with me. I actually recently, as a pandemic project, put all my cases onto a Google Drive document. And so now I take, instead of paper, I take 3 tablets to court. Wow. I give one to the judge, one to the DA, and I have one, and then we can look at cases together, and the tablets are connected to the internet, so the judge can log into Westlaw if he feels like he needs to look at another case. He can always do that from the tablet, and it makes it a lot easier than carrying all the paper cases. And it also doesn't kill as many trees. I guess that's some consideration, trying not to waste a lot of paper. And the Google Drive document allows me to put pretty much everything I've collected over the years in that. So I have a big case list that the website list came from that I carry with me so that I'm available. So when the judge says, I stand up and say, that's not what the law says. And the judge says, well, what is the law? I say, let's go together to the 3rd case in this folder. And then you'll look at the 2nd page and you see the highlighted portion. That's what the law says. And then, that makes it really difficult for the DA to say, well, but I have a summary here.
Yeah, that's right.
Read the whole case if you want. Here's the case. Now let's make arguments not from someone else summarizing it from the actual case. And Mr. DA, you have the case. Take your time and read it and see if you have an argument here.
Yeah, no, I love
instead of being a jerk about it.
No, I think that's so powerful. I mean, that's what a great use of technology. I mean, I think we're definitely underutilizing the technology that is available in, whether it's the technology that is available within the courtroom itself, using some of, a lot of courthouses now have monitors at every table that you can plug into, but also, I mean, even just like you're doing, just bringing your own technology. And that way it's kind of like, nothing can really get in the way of us being able to look at this together. That's amazing.
Well, and it makes it easier. And I think, I've had some judges that are very resistant. I want paper. I'm like, Judge, I'm sorry, I don't have paper. And I can go print these out if you want to give me a 30-minute break while I go, find a computer and get a printer, or you can read this like everybody reads with the scrolls and that. Anyway, you do have some Luddite judges, as you know, but mostly people have been grateful because they say this is a good use and this way I can access it all. And they're like, the other thing the judges want to do is access the Google Drive document on their computer. And I'm not doing that because I'm not giving everybody in the world access to that because I built it. But I still do have the cases list, which is pretty much what the cases on the tablet are. And so I provided those to everybody because I think, that's a good incentive to read cases and to do your homework, which I wish everybody did. And I try to do myself. We all get behind. I mean, you've been doing this a long time. I've been doing this a very long time, and you get behind sometimes, but you take a weekend and catch back up and go through cases and read. And I think it really helps. And developing that reputation is one of the reasons that I get a little better results than some people because they think I know.
Exactly. No, I think it's a cumulative effect, not only helpful for the individual case to know that stuff, but it is that kind of becoming, looked at as an expert in the field and kind of having a good understanding of that. To kind of go back to your district court process that I derailed you from there, in terms you were talking about how you would have your client in a lot of these DWI cases go out and do some discovery at the accident scene or at the stop scene, whatever it might be. I think that having a knowledge of what that looks like was critical. This was something that, early on in practice, I didn't know what I was doing. So I was like, at least I can go check out the site and kind of figure out what's going on. And I think that being able to have a very specific detail about where this occurred already gets the officer thinking that you know more than you do about the case. I mean, it already is like a psychological weapon in terms of kind of putting you in the driver's seat from a question standpoint. Sometimes there are really powerful things that you can pull out of that kind of locational investigation. Are there any tips or things that you've kind of found useful in doing that kind of, stop site investigation?
Well, one of the things I found is it's often true that the officer does the field sobriety test, which are coordination tests other than the HGN, the one leg stand, the walk and turn. They're doing those at inappropriate places.
Yes.
And I think standing beside an interstate between a police car and your car is an inappropriate place. It's often true that there's a good spot to do it not far away. So one of the things I do is ask my clients to find a better place and then walk there while carrying the camera. And
that's awesome.
So the police officer will say, "Oh, that was way too far. I understand that. Let me show you the video of us walking to this better place." Once again, it just makes them feel like they should have done a little better investigation, been a little bit more careful. And I think from a judge perspective or a jury perspective, they expect the police officers to do all the investigation correctly. And when they don't, they tend to punish them. So I like having a sidewalk 15 feet away that was level and pretty well lit and not standing between two cars with big trucks going by all the time.
Yeah, I've not taken that approach very often in terms of I've done that in kind of a handful of cases, but I've kind of missed an opportunity now that you're talking through that. We had several troopers that for a while were just doing HGN on most of their interstate stops and just saying there wasn't an appropriate place to do the other tests. And I think that would have been pretty easy to actually show that there was a location nearby where those could have been performed. So for anybody that's kind of hearing that response out there, that there just wasn't a good location, there's got to be a good location somewhere. I mean, it's almost always going to be the case that there's somewhere to do those field sobriety tests.
Sure. And to give the defendant an opportunity to show sobriety. So I think it's important that you're gentle with that with the officer. I think, I've seen lawyers kind of do the, aha, gotcha.
Yeah.
Never do that. You want to just say, I know you got a tough job and it was probably a long night. You've been 4 hours into a 12-hour shift and it's drizzling a little and you really wish you weren't standing out in the cold rain. I understand all that. But if there was a better place, if there was a place to do them, so I couldn't do those tests, but if there was a relatively safe, better place to do it in a very short distance from where you stopped him, you would have done that, right? Yeah. but did you look around for a better place? No. Can I show you a video of what we saw when we went out there? And once again, that just makes the officer look like he hadn't done your job. And I don't think he can get angry at you.
Right.
For that. You're not personally attacking him. You're just saying you should have done a little better job. And I've had many officers say, you're great quality control, because at the end of a trial with you, I know the things I need to improve. I'm hoping they don't, to be clear. but that's what they say. And I think, all I'm saying is an officer told me that once, and I said, yeah, you can fix all the things I showed you today, but I'll think some other things.
Yeah. No, well, and I do think that is, an important way of, I think that's an important part of what the defense bar does, is to really improve the quality of policing. I mean, it's inevitable that the quality of policing will get better after somebody's been hit, with an issue on the stand. They're not going to forget that. And good. At the end of the day, if there's a better investigation that is going on, even if, again, the result in the courtroom isn't what we're hoping for, there is a bigger value in terms of what happens from that. So I think that, there's definitely been many times, and I know a number of other lawyers that have had this, circumstance where an officer walks up after trial and is just like, dang, I won't do it like that again. That's an inevitable part of the value that we bring to the courtroom.
And a good part of it too. I think the other thing that goes along with that is be nice to your officers. And,
yes.
Treat them like human beings. And if they make a mistake, I don't give anybody a hard time for making a mistake. I make mistakes. You make mistakes. We all make mistakes. I think you should, say, hey, you made a mistake, but that's not because you're a bad or evil person. We all make mistakes. Don't take it too hard. Learn the lesson. I'll do better next time. You'll do better next time. I think that the other good thing is when officers hire you. I had an officer who had a DWI, and he hired me, and I asked him why, and he said, well, I was on the witness stand with you one time and it was the worst experience of my police career. I said, if I'm ever hiring a lawyer, I'm hiring that one.
That's well, as an officer, you get to see a lot of attorneys in the courtroom. So again, that's a sign that you're doing the right things, as a defense lawyer. If that's kind of the reputation that you've earned in the courtroom. And obviously you do that through practice and doing it again and again, but it's part of the reason why I think it is important to try cases, because everybody that's in that courtroom is a potential referral, whether it's the clerk, the bailiff, the other attorneys that are in the courtroom, officers, everybody knows somebody that's getting a ticket or is getting, some sort of vehicle violation or DWI, whatever it might be. And if you're the guy that's kind of going to bat for clients, regardless of whether or not they had a good experience with you, it's kind of like, this is the right person if you're in trouble.
Yep. So we're coming up on the end of the hour, but I did want to say thanks a lot. I appreciate what you've done. And I think what you're doing here is valuable and useful. You're putting on a lot of leading lights, not including me personally. I don't know why you picked me, but there's others that are really smart that you put on. I found it very useful. So I appreciate you taking the time to speak to me.
Yeah, thanks very much, Marcus. I appreciate everything on your end. If I can just ask you one more question, do you have any specific advice that you would give to young lawyers? Just any tip or practice point, anything specifically outside of what we've already talked about?
Well, yeah, when I talk to young lawyers and young people, I think the first and most important thing is to give shit. To actually care about what you're doing and making sure that you did it right. Early in my career, a lawyer told me, nobody else will know you did it right, but if you did it right, you'll know that and you'll feel better about yourself. I think you can't do it right unless you care. And that means there are nights when I go home and throw rocks at the moon and scream and howl. Dead cat, because I'm so angry. I don't let that show in the courtroom, but I get angry. But I don't think a job that I didn't do that with would keep me alert and enjoying it after this many years. So care about your cases, try to do it right. Think of a better way to do it. Learn from your mistakes, which you will make. And, but don't forget that the first thing, the thing I can't really teach you, but the thing I urge you to do is to care about your clients and to give them space to be real people. And I think if you do that, you'll be doing the rest of the stuff well.
I love that. Great answer, Marcus. I appreciate it very much. If you found the information in this podcast to be valuable, I simply ask that you pay it forward and share this podcast with another member of the legal community. Also, if you would leave us a rating or a review on whatever platform you're listening on, I would greatly appreciate it.